Hi everyone, and thank you for joining us for part 2. If you missed part 1, we discussed the basics of the 101 section of the U.S. Code, which describes what is considered eligible for patenting. Then we discussed relevant software patent court cases and what the holdings were in each of those. Then we discussed some application drafting tips. However, if you think that what you have is not protectable by utility patent, there are some alternatives for you, which we will be describing now in this part 2. So some alternatives are design patents, copyright, trade secret, and of course do nothing. We caution against doing nothing because obviously you have no recourse, but there are cases where being faster, better, cheaper is maybe the best route for you. But let's first focus on design patents. Design patents protect the ornamental design of a product. So for example, you may protect the user interface layer or the UX layout or icons, the appearance of your landing page. The good news is that there's no 101 requirement. There's no hurdle for 101, but it still must be novel and non-obvious, just like utility patents. Some examples of design patents is the springboard for Apple, the Facebook main page, and then the Google landing page. And you can see that anything in the solid line, not dashed, is what is being protected. And so these are relatively broad patents. So design patents may be a good alternative for protecting your software innovation. Additionally, you can also pursue copyrights. These can be used to protect your software code. But it has to be published software code, right? It has to be in the public domain. The advantage is that it's easier, faster, and cheaper than patents. All it requires is 2 copies of the work fixed in a tangible medium. And the registration of the work with the Library of Congress is very cheap, or the Copyright Office is very cheap. And they're granted immediately upon creation. The disadvantages are that it's limited protection. It only covers the particular expression of an idea, not the idea itself. So typically with utility patents, you're more protecting the idea itself, right? You're protecting kind of the general overall idea, not necessarily how it was executed. In contrasting that to copyrights, copyright is really the particular expression of the idea, for example, executed in software code. It also requires public disclosure of the code, because that's one of the requirements for copywriting. And if someone is infringing your copyright, they may have a fair use doctrine as a potential defense, which means that maybe they argue that they're using a very small portion of it, or they're using it for educational purposes, or they're not selling it or anything like that. And so they may be able to get out of it. And so significant limitations to copyrights. An example of copyrightable software is the Java API taxonomy, which was found to be copyrightable in 2014. Trade secrets. These can be used to protect any information that derives economic value from not being generally known and is subject to reasonable efforts to be kept secret. Examples of best uses for this are source code, internal software, other code that is neither publicly available nor easily reverse engineered. But again, you still have to derive economic benefit from it. The advantages are that, of course, there's no public disclosure because you have to keep it secret. And there's no formal process or filing fees because the main burden is that you just keep it secret and take measures to keep it secret. Disadvantages are that if somebody independently derives it or reverse engineers it or independently creates it, you have no recourse. It's really only if someone misappropriates your trade secret, meaning stealing it or sharing it when they're not supposed to. So what are reasonable efforts to keep a software secret? They may include marking documents as confidential, requiring any third parties to sign an NDA, requiring all employees to sign confidentiality agreements, establishing strong document retention policies, or even the ability to wipe computers once an employee leaves your company, establishing reasonable physical security measures, so maybe door locks and passcodes on computers and similar measures, or setting access controls on code repositories so only certain people can gain access to the code. So what happens if somebody subsequently patents your trade secreted product or your software? And this is a question that we get a lot from our clients, that if I decide to go the trade secret route, what if somebody later patents it and then tries to prevent me from actually using the software even though I had been using it previously? The 2 major ways you can go about it are the prior use defense, basically which states that you were using it prior to them patenting it, or you can also seek to invalidate the patent. And so we'll kind of talk about each of these quickly in turn. So the prior use defense was first created in response to State Street Bank and Trust versus in State Street Bank and Trust. The Federal Circuit held that business methods are patentable. So in response to this court case, the Congress created a prior use defense for infringement of business method patents, basically to prevent exactly the scenario which I'm describing. However, in the AIA, it was somewhat expanded to beyond business method patents to include obviously like manufacturing methods or other methods that may be not fully publicly visible. And so the defense cannot be used against any patent issued on or after September 16, 2011. So this could include patented processes, machines, manufacturers, or compositions of matter used in manufacturing or other commercial processes. The exception is that university patents are excluded. You cannot use the prior use defense against patents owned or subject to assignment to a university or university's tech transfer entity. So a prior user is a qualifying entity so this is the person who may be infringing a patent, but where they were using the technology prior to it being patented. So a qualifying entity who can prove by clear and convincing evidence that it engaged in commercial use in the U.S. more than 1 year before the earlier of the patent's effective filing date or the 102B public disclosure date without derivation or abandonment. So more than 1 year in the U.S. And that you engaged in commercial use of the technology and you didn't abandon it or derive it from somebody else, for instance, the people who patented it. So qualifying entity is the person who performed or directed the performance of the commercial use, or the entity that is controlled by or is under common control with such person. So that's the person that at the time of the commercial use was controlling what was happening, controlling the commercial use. Commercial use includes internal commercial use, sale or transfer of an end result of the use during pre-marketing regulatory review, for example, with the FDA, or nonprofit use by a laboratory or other nonprofit for which the public is the intended beneficiary. So these are examples of commercial use. This cannot, if you have derived it, for example, reverse engineered it, observed it, or had used some other method of obtaining it, you cannot use the prior use defense. Or if you were using it and then you abandoned it, the 1 year clock restarts. So you cannot rely on pre-abandonment activities for proving prior use. So it's only activities that occurred after the abandonment if you did abandon it. So these are the two exceptions to the prior use defense, or two of the major exceptions, I should say. So is this a meaningful defense? Well, that remains to be seen. It's only been asserted a few times since it was enacted in 2011. In Auburn University versus International Business Machines, or IBM, the 273 motion was denied as moot because there was no infringement. And then in Vaughn versus Global Biofuels Tech, the 273 defense was without merit. And then in Dunnhumby versus Emnos, the 273 defense was found valid because the current parent company engaged in prior use since 2003. So you can see that there still remains much room for additional case law to be generated. So what are the risks to using the prior use defense? Obviously, it's the increased cost and invasiveness of discovery. They may actually find that you infringed in this process, but that you do not qualify for the prior use defense. So obviously, that could be very bad if you were trying to use this defense. But the standard is clear and convincing evidence, and standard for infringement is preponderance of the evidence. So two different standards there, but definitely a risk that you have to be willing to take in order to enact this prior use defense. So what are some other ways that you can get out of the scenario that I described, which is someone patents your technology that you were using previously? Many people seek to just invalidate the patent since it doesn't really open up the can of worms of prior use and infringement. So the defensive approach is obviously patent infringement litigation, which can be extremely expensive. But you can also do the covered business method review, which basically in business method patents, you can use the PTAB, the Patent and Trademark Appeals Board, to file a CBM review, and basically you can raise any invalidity challenge. But as I said, it's limited to claims directed to the practice, administration, or management of a financial product or service that do not claim a technological invention. So it is limited, but a good option. And the offensive approach is to try to invalidate the patent offensively. So basically doing a post-grant review. You must file this within 9 months of the patent being granted, and you can raise any invalidity challenge 101, 102, 103, or 112. But you could also do inter partes review, and this can be filed following the post-grant review window. But it's limited in what you can raise. You can only raise 102, 103 issues. And so if you want to invalidate a patent, like I said, there are a couple of different approaches, and it's probably the better approach if you are accused of infringement versus the prior use defense. But that remains to be seen. As more case law comes out, we may be surprised. But with that, I hope the collection of Part 1 and Part 2 have been useful to you, and that you've learned a few things about software patent court cases that have occurred since Alice, and how you can protect your software innovation or protect yourself in the case where maybe you've decided to trade secret a product. And so, please feel free to email us any questions. We'd love to hear more from you. So please contact us, and we'd like to work with you. So give us a call. Thanks.